We are back. Welcome to another IP lawsuit breakdown, man. I tell you what, technology. I didn't think I was gonna make it today. The technology was messing up, but we got it figured out. We back here. Hey, how y'all feeling today? Check in the chat. It's been a while. It's definitely been a few weeks before I actually done one live. I think a couple weeks ago I did a pre-recorded, sent that out on Sunday night. But I'm glad to be back and doing this with you guys live and seeing what you guys have to say, really interacting with you guys in the chat. I'm not sure what's going on in North Carolina, but it seems like these restaurants are really having some issues in the great state of North Carolina. Who are we talking about today? We are talking about the one and only Subway. They just sued a franchise owner, a former franchise owner, I'll just say, out there in Subway. Let me bring it back on myself. So I didn't realize that Subway had 44,000 locations across 110 countries. So, Subway, it's a big company and they sold, I think, a couple years ago for $10 billion. So big company, respected company. And it seems like one of the former franchisees has went rogue, which I'll kind of give a summary and then we'll break down a lawsuit. Interested to see or hear what you guys have to say in the chat. So please, don't hesitate to type in your comments as I'm going through this. Man, restaurants is an interesting thing for me. I don't think I can own a restaurant. However, if you are going to own a restaurant, number one, you need to always protect the IP. I'm big on protecting IP, intellectual property, whether it's trademark, whether it's trade secrets, whatever the case may be, copyrights. Make sure you are protecting your intellectual property. But if you are going to run a restaurant, man, I suggest you go for the stars, go for the moons. Forget all this. Let me get one restaurant or maybe two restaurants and ride off into the sunset. And I know we normally have Taylor in the chat. I'm not sure if he is in today, but he's a mergers and acquisitions attorney. He'll tell you, man, the more restaurants, the better, because when you're looking to sell these things, sell your restaurant, sell your franchise, the more restaurants, the better. Once you get 10 restaurants and those, say 10 restaurants are doing $1 million each in revenue, you can sell your restaurant for $10 million. So again, for all of the watchers, listeners who are maybe thinking about getting into the restaurant game, if you do, again, I'm an attorney, but just my 2 cents. If you do, hey, try to get a franchise out of these things as opposed to having a 1-2 restaurants, 2-off restaurants, and just trying to ride it off into the sunset, because again, you're going to make more money, at least in the long run, operating a ton of restaurants, at least 10, 20 restaurants, as opposed to having just 1 or 2. But let me kind of break down this franchisee, franchisor dynamic, because a lot of people really don't understand it. So you have the franchise, which, again, gentlemen, we talked about Whataburger a couple weeks ago, that started in Texas and had, I think, sold once it got 700 restaurants, and now I think, over 1,000 restaurants, and they sold their restaurants to a private equity firm in Chicago. And going back to North Carolina, they were in some, say, back and forth, some heated back and forth with one of the restaurants that a Whataburger restaurant in North Carolina that was operating, because, in my opinion, Whataburger in Texas dropped the ball. However, with the franchisee, franchisor, the franchisor is the owner of the trademark. Normally, they started the restaurant and they have all the rights to the intellectual property, the trade secrets, things of that sort of the restaurants. And then you have a franchisee. So say, you come along and, okay, I want a Subway restaurant. You have to go to the franchisor, essentially get authorization to operate your restaurant using, say, their intellectual property, the trademarks, things like that. And then they're going to give you constraints, if you will, that you have to follow in order to continue to run your restaurant. However, there are two separate entities: the franchisor, which they have their own LLC or S Corp or C Corp, or however they structured their corporation. But you, as a franchisee, you have your separate LLC that, again, is really separate from the franchisor, aside from you being able to use their intellectual property. And then obviously, there's money involved in terms of you having to pay a fee, a franchise fee, in order to be able to use the intellectual property of that franchisor. So that's kind of that franchisee, franchisor dynamic. And to the extent that you are no longer operating your restaurant under the umbrella of the franchisor. So, for example, if you're not following the guidelines and rules that's laid out by the franchisor, and therefore the agreement terminates, you then have to destroy, dispose, get rid of all of your intellectual property, whether it's trademarks, whether it's trade secrets. If you're using the systems and the processes of that franchisor, you have to dispose of that. And essentially have to, a lot of times it may be even a non-compete agreement, which we'll get off into later, that you have to where you cannot even run a restaurant within that same industry for a number of years. But you essentially have to dispose of all that and kind of go about your business. And to the extent that you don't, then you are in breach of agreement of not only intellectual property infringement, but also a breach of a contractual agreement. So hopefully you guys kind of understand that. I do really want to break that down as we get off into it, because this is our first time going over franchisee franchisor dynamic, that relationship, and it's going to be important to note that. Now, I was actually at Bigby, man, and I had the co-founder of Bigby, Mike McFall, on the interview. So you guys please go check out that interview in the archive. But I had him on, Mike McFall, and this is pretty interesting because Fred DeLuca, the co-founder of Subway, who's now passed away, so RIP Fred DeLuca, he actually was going to invest in Bigby back in the day, and unfortunately he had an untimely pass, and that just never materialized. But he was very important in what Bigby has done today. Gave Mike McFall, the other co-founder, a lot of guidance, information on how to run a restaurant, how to essentially run a franchise. And it seems like Bigby has capitalized off that big time. I think they're up to 400 stores now, doing hundreds of $millions in revenue. So I mean, they're killing it essentially, and they have Fred DeLuca as a large, to thank for that. So again, shout out to Fred DeLuca. I definitely wanted to pay respects early, and I was actually at a Bigby earlier and kind of talking to one of the franchisees of Bigby that I have a really close relationship with about what I was going to do, talking about Subway in this live here tonight. And she was like, "Oh, that's pretty interesting." And she actually was saying that one of the franchisees of Bigby had a similar situation where Bigby, the franchise, had to, sue a franchisee because they were doing some similar things in terms of, okay, the agreement terminated, the lease terminated, and they were still operating as a coffee shop, kind of using Bigby IP, and kind of Bigby had slapped them with a lawsuit. So this stuff is more common than what you think. This is more common than what you think. So let me break down you guys a summary of what happened. We'll get off into the lawsuit and kind of go from there. Again, please, I know we have a couple viewers here, so kind of please tap in the chat. Like I said, I know it's been a long time. I love interacting with you guys back and forth in the chat on this one. So don't hesitate to leave your comments, leave your questions in the chat as we're going through. So this is what you had here. North Carolina, you had a gentleman who, again, was a franchisee, operating a Subway as a franchisee. And it was something about the lease that it just ended up terminating. He didn't renew the lease, so that, again, as a result of him no longer being a franchisee or authorized franchisee, at least of Subway, he had to dispose of the signs, dispose of all the intellectual property of the trademarks, the trade secrets, which includes the systems and processes that kind of Subway operates to make them run smoothly, all the signage, things like that. And unfortunately, he, at least according to Subway, to the complaint that we'll read here in a second, he not only did not do that, but he kept going. He just changed the name to Sub, but all the interior as far as all the signage, and we'll check it out in the lawsuit, the ovens, the Subway ovens, the signage, the menu, everything, even like the layout of how Subway does its vegetables and meats and all that. He left that the same, and Subway found out about it. They tried to give him a call, worked it out. That didn't work. They sent him a cease and desist letter, which we will check out. That still didn't work, and they essentially slapped him with a lawsuit. And it was interesting because the sub, it seems like he went into partnership with a couple other guys, or the guys, essentially, the other two guys were pretty much the owners of the sub. And the guy was, according to Subway, he still had interest in it, although the guy in the complaint, the complaint said, "Hey man, I have nothing to do with this. It's these guys' shop." Even though Subway, they dispute that and say, "No, this guy has some he has some ownership, he has some stake in the actual sub restaurant." Look, man, if you're gonna not run a Subway restaurant anymore, you may want to come up with a more creative name than sub, as well as got to leave, change out all the signage and menu items and all that stuff. So man, this guy rode into it, but let's get off into it. Let's get off into it here. and go through it. This is an interesting one, man. And I'm excited because we haven't talked about like that franchise or franchisee a relationship. So let's get off into it. Hopefully you guys see my yellow cursor. I tried to make it so that you guys can see this. Let me blow it up. So what do we have? It seems like a lot of these cases get filed in New York, but this time around we are in Raleigh, North Carolina, between Subway IP and Doctorate of Associates LLC versus 706 Peace LLC and Ahmad Sider. And I guess please take note of this Subway IP LLC as well as Doctors Associates LLC. So as I bring it back on me, really, Doctors Associates LLC is essentially the operating company. And this all kind of makes sense and comes full circle for me because as I was talking to the Bigby founder, Mike McFarland, he talked about how he has the operation company, the company that operates Bigby, but then he has a separate LLC that essentially owns the IP. And I would imagine that he got that from Fred DeLuca because Subway, as we're kind of looking at this complaint here, they essentially have a similar setup where Subway IP LLC owns all the intellectual property for Subway. Then Doctors Associates LLC, or what we will consider as DAL, D-A-L, the acronym, they are essentially the operating company. They are suing 706 Peace LLC. Let's go off to the nature of the action. Obviously we're going to try to read a lot of it. We're not going to read all 25 pages of this thing, but we're going to try to read a lot of it. So plaintiff Dow is the franchisor of Subway sandwich restaurants in the U.S. Its founder, Fred DeLuca, I talked about him earlier, started the first Subway with the goal of providing healthy, affordable, and convenient food. You guys, let me know in the chat, when is the last time you guys had Subway? Man, I have a love-hate relationship with Subway where it is fast. They actually have some pretty good food, but what I found out over the years is depending on what location you go to, man, you can have a good Subway sandwich or you can have a not so good Subway sandwich, we'll call it, just kind of depending on what Subway location you go to, which is interesting because the whole part of a franchisee is the fact that it's supposed to be similar, it's supposed to be the same, it's supposed to be essentially regardless of what Subway location you go to, the product, the food, the Subway sandwich in this case should be the same. But I have found that that's not always the case with Subway. So I have a love-hate relationship with Subway. But I still partake in their food, some good subs, affordable subs. So let's continue with this thing. Based on that vision, Subway restaurants rapidly grew from a single location to an internationally recognized brand with more than 44,000 Subway locations operating in 110 countries around the world. That's crazy. So plaintiff SIP owns the proprietary system for establishing and operating restaurants that made the growth possible. SIP is the owner and licensor of the Subway trademarks and all the recipes, formulas, food preparation procedures, trade dress, essentially all the IP. So that's what I talked about yesterday. The two plaintiffs is SIP, which is the Subway intellectual property or the entity that owns the intellectual property. Then you have Dow, which is the Dr. Associates LLC, and that's essentially the operating company. So both SIP and Dow are suing the defendant in this case. So the system owned by SIP includes not only the confidential operating methods and recipes for a Subway restaurant, but also all of the trademarks, logos, branding, trade dress, copyrighted material. So again, they own all the intellectual property. And to be honest, I would think that the intellectual property that Subway has is worth tens of millions of dollars, if not more, in and of itself. So SIP licensed the system to Dow to develop Subway restaurants in the U.S. and its territories. The reputation and goodwill attached to these trademarks are central to plaintiff's business. And let me talk about that whole aspect of licensing. And again, man, you guys got to really go check out that interview I did with Mike McFarland, the co-founder of Big, because he talked about the benefits of this setup where you have the IP company and then the operating company. And the operating company essentially is paying the company that owns IP a license fee to use the license. Use the intellectual property of the licensing of the IP company. And that kind of authenticates or gives credibility to the value of the trade of all the intellectual property. So, and why do you want to get the value of the intellectual property on record? Because you can go take loans against the intellectual property. You can go sell off the intellectual property. You can do a lot of things with intellectual property in and of itself that's separate from the actual the company that operates the restaurant, in this case, Subway. So it's actually, it's a pretty good setup to have the IP, the company that owns IP, separate from the company that owns the operations. Not to mention, we have that level of protection where if somebody come try, say somebody slips and falls in Subway and wants to sue Subway, the operating company, they cannot attach to the IP, which is the value of the company, all the intellectual property, the systems, and the processes, the trade dress, the copyright, all that stuff is owned by the IP company. So if somebody tries to sue for slip and fall, for example, Subway, the company that operates the Subway, they cannot get get any it doesn't attach to the company that owns the IP. So this is actually a beneficial arrangement that they have here. So let's go. We're on item 3 here. Jihad Kader is an authorized Subway franchisee who operated a Subway restaurant on P Street in North Carolina until around December 1st, 2023, at which time he ceased operations. So it seems like up until December 1st, 2023, this gentleman, Jihad Kader, was an authorized franchisee. At the time he ceased operations, Mr. Kader was required under his franchise agreement with Dow to de-identify the premises, but did not do so. In May of 2024, so just a couple months ago, Dow discovered that a restaurant called Sub was now operating at the premises. Man, you know what? It seems like Subway has a drop in communication. Because if we're saying that the franchisee, the authorized franchisee, Mr. Kader, was ceasing operation of December 2023, but it's in Subway didn't find out that he did not de-identify the premises until May 24th, 5 months later. It seems like at least a couple months, 1 month, 2 months, maybe even 3 months, somebody should have been out to the Subway on P Street just to confirm, validate that Mr. Kader actually ceased operation. So it seems like that's kind of a breakdown in the systems, because, man, to let 5 months go by and found out that this guy's still making money under a sub, that seems odd to me. But let me know what you guys think. Okay, the premises is still identified as Subway restaurant in virtually all respects. Subway trademarks and colors abound. The entire menu board is for Subway restaurant. The copyrighted veggie mural remains in place, as does the distinctive floor tile, wallpaper, lighting. So essentially, this guy, he just changed the name. So, you have the Subway name out. He probably put the sub name and left everything else the same, which we will show based on some images in here in the complaint. That's probably not a smart idea to do. Again, this guy seemed like he was lazy, which whatever. But if you're going to, I'm not going to say that, but I was going to say, if you're going to maybe try to do something like this, you probably want to get a little bit, not only creative, but change a little bit more than just the name and leave everything else the same. So this guy wasn't a smart infringer, but it is what it is. Let's get back to the lawsuit. So item 4 here, plaintiff immediately contacted Mr. Kader. So Subway contacted the defendant, who claimed that the defendants are operating a sub restaurant and denied involvement. Plaintiffs have reasons to believe that Mr. Kader is somehow involved. So, hey, Mr. Kader, like, man, they own that. I don't got nothing to do with this. So it seems like Mr. Kader is somehow, so essentially Subway has reason to believe that Mr. Kader is somehow involved and is working with the defendants to operate the sub in violation of numerous provisions of his franchise agreement. But whether or not Mr. Kader has any involvement, the fact remains that defendants are not authorized franchisees and have no right to operate a restaurant using plaintiffs' essentially intellectual property. Going to figure 5 here. So essentially what Subway is saying, look, we still think Mr. Kader has some involvement, but setting that aside, the defendants, they have no right to, they're not an authorized franchisee. So them using our murals and our copyright, our intellectual property, our menus, our color schemes, all that stuff, they are not authorized to do that, which, again, they have a point. And they still seem like they got Mr. Kader on a breach of contract, but we'll get off into that. Here we go, item 5 here. As described hereafter, the defendant's conduct violates a long list of rights enjoyed by plaintiff. We're not going to go over all those rights. And then 6 here, plaintiff seeks injunctive relief, essentially to cease all the illegal use of IP and also seek damages and other relief defendants in order to halt the blatant violations of various state and federal laws and to halt the illegal activity and deception that defendants have launched. It's definitely deception, but we'll get off into it here. So obviously plaintiffs, Dow and SIP, they Delaware companies. Defendant, P Street, North Carolina, is a company in North Carolina. And then Ahmad Sider is the manager. So it seems like Ahmad is the manager, one of the owners at the P Street location, and the citizens of North Carolina. Obviously, Mr. Kader, the former authorized franchisee of Subway, is also in North Carolina. We're gonna skip the jurisdiction. Okay, let's get to the background, which is some good information. Plaintiff's trademarks, copyrights, and IP. Again, this IP is valuable. Val is the franchisor of Subway restaurant system in the U.S. So we talked about them having 44,000 locations in 110 countries worldwide or internationally. They also have 20,000 locations in the U.S. So again, Subway is, it's a big deal. In those instances where the operation of a Subway restaurant is franchised, the obligation and duties of the franchisee are subject and governed by the terms written of the franchise agreement. So I talked about that earlier, which again, if you own a restaurant out there, number one, coming from an IP attorney, get your IP protected. But number two, hey, I would shoot for the stars. Nah, forget all this. I'm gonna get one restaurant, two restaurants, maybe three restaurants. I mean, I'm saying go for the stars, get as many restaurants as you can. So when you go have an exit, as opposed to getting, say, $200,000 for that one restaurant, or maybe $400,000 because you have two restaurants, you are likely to get millions of dollars for having at least 10, 15, 20 restaurants. I think the Whataburger, when they sold at 700, I think they sold for like hundreds of millions of dollars. So again, man, this stuff is valuable. So let's get back to it here. Let's get back to it. So then it's talking about that SIP owns all the IP, trademarks, trade dress, logos, all that stuff we went through. So this is the trademark. These are the trademarks. And actually, Subway has a number of trademarks. You have just the Subway name, Subway. You have the stylized Subway that are more recent trademarks. I'm not sure what BMT and the Outlaw stand. I think the Outlaw was a sandwich. Then they essentially have all their sandwich names trademarked. Sweet onion chicken teriyaki. I was a big fan of that. That American Club was good. The Subway Club was pretty good as well. And which one of you guys? Let me know in the chat. What was your most favorite subs out of these? The BMT? I'm not familiar with that one. The Outlaw was pretty good. I like that sweet onion chicken teriyaki. That joint used to slap. The All-American Club, the Subway Club was good. And then I guess I never tried the Veggie Delight as well as the Cold Cut Combo. There was another one. They kind of missing some subs on here. Anyway, 18, the U.S. trademark registration numbers listed above for various marks with and without design are in full force and effect. Incontestable, I would imagine. So when they say incontestable, that means that the trademark has been valid and operating for longer than 5 years. And once it does that for 5 years, it becomes an incontestable mark. And it's essentially come with some added protections. And it's tougher for someone to say, hey, they don't have a trademark as an invalid trademark. So just remember that, so that when you go get your trademark, try to get it in good standing for 5 years, five consecutive years, because it becomes incontestable. SIP is the owner of the above referenced marks. And okay, goodwill. We're going to skip that one. Let's go to 20 here. So plaintiffs has expended time, money, and effort in developing, advertising, and promoting the Subway franchise system in connection with these and other Subway marks. Plaintiffs have made such an investment to cause consumers to recognize the Subway marks as distinctly designating Subway restaurants, all in order to further develop and trade upon the goodwill associated with Subway mark. For example, millions of dollars have been spent on the introduction of the Subway series menu of distinctively named sandwiches and that are offered in all Subway restaurants. So this is Subway series. This is obviously a new thing. Like I said, you see it 2022. I was going to say, man, this is a relatively new thing just a couple years ago. Not sure if I've been to the Subway in the last couple of years. But again, it seems like this is a new thing that it looks like they have a trademark on. 22 here. Additionally, SIP owns the right to various trade dress. So when you think of trade dress, and this is interesting, and we talked about this, I don't think we talked about it on the live, but some of the more current events, what I break down and do VODs on, I talk about the trade dresses, especially as it relates to Nike and its Jordan 1s and the Air Force 1s. Essentially, trade dress is the look and feel of, in that case, the shoe, but also in this case, when you go into a restaurant, you're like, man, this look like a X restaurant or look like a Y restaurant. That's the trade dress of the restaurant, the look and feel of that restaurant, which is protectable. A lot of people don't know that, but you can protect the trade dress or the look and feel of the restaurant, which I think we all know that if you go into a Subway restaurant, you would probably know that it's a Subway restaurant based on the color scheme, based on where things are positioned, kind of how the layout of the vegetables and the cold cuts are. So again, trade dress is protectable. So I do want to kind of point that out, because a lot of people don't kind of really know that, but you can protect kind of the look and feel, or what is called the trade dress of no different things in this case for restaurants. We're going to skip the rest of that though. So similarly, many Subway restaurants employ a distinctive green and yellow color scheme, which I was just talking about. That goes towards the trade dress and lettering fonts, and its branding decor. That's all trade dress. That's protectable. Thousands of Subway restaurants also employ a style of interior decor that has a specific set of hanging pendant lights, brownish tiles, and a specific pattern on the floor and brick backdrop behind the order counter. Again, that's all trade dress and is protectable. Each franchisee of the Subway franchise system is granted a non-exclusive limited license from plaintiffs, essentially Subway, to operate the stores and essentially uses IP. Okay, let's get off into the sub restaurant. This is where it gets good in the wrongdoings of the defendant. The heart of the defendant's wrongful conduct is operated of a copycat knockoff sandwich businesses located at this premises. In May 2024, plaintiffs became aware of a sandwich business located at the premises under the name Sub. Again, this is not a creative name. If you're going to essentially have a knockoff restaurant, which you shouldn't be doing anyway, you probably want to have a more creative name than Sub. That's a lazy way to, in my opinion, to go out, but it is what it is. On or about December 1st of 2023, Dial approved a request from Cotter to close the. That's crazy. You actually have to get approval from the franchisor to close the restaurant, which it seems like Cotter got approval from. Cotter requested to close his franchise Subway because the lease of the location claimed expired on. So how many people think, based on the chat, you guys let me know in the chat, and it seems like Brandon, what did he say? Well, the fact that you can trademark the trade dress of a restaurant is insane. It's like codes inside of the codes. Exactly. And again, a lot of people don't know that, but it becomes important because have you ever went into a restaurant and you're like, man, I like the ambiance of this thing. I like the look and feel of it. That becomes important to the consumer just as much as the food. And it's almost like the food is I actually was taking a date. This was a while ago to Eddie V's, and she walked in. She's like, man, I actually like the ambiance of this. All that is trade dress, and it becomes important to the consumer going into it. Hey, like, man, let's go to Eddie V's, because not only do I like the actual food, but I just kind of like the interior decor, which is all protectable to kind of lure people in. So again, I definitely agree with that. It's definitely insane, and people just don't know about it. But people, I think, need to really start taking advantage of that. Again, it's important stuff. Let's get back to it here. So I was going to say, so this paragraph is saying that Cotter requested to close his franchise agreement, a franchise with Subway, because the lease had claimed to expire on November 30th, 2023, and upon information and belief, Cotter did not want to expend the funds to try to renegotiate a new lease at his Subway restaurant was due for a remodel that he would be required to complete had the restaurant continue to operate. So let me break this down, because I think this is a turning point in this case, and this is a very important turning point. So as I talked about, when you sign these franchisor agreements, these franchise agreements, you have to essentially uphold the standards, not only of kind of the goodwill of the products that you're selling and all that, but you remember all those McDonald's that recently changed. Initially McDonald's had this kind of bright color scheme, and it kind of went to this more so kind of dark color scheme. Well, as part of your franchise agreement, that cost, it's not like the franchisor is coming to everybody's store and say, hey, we're doing X, Y, and Z. That cost is paid or passed down to the franchisee. So you, as an owner of that franchisee, you have to actually spend your own money or the money generated by your restaurant to update your restaurant when the franchisor says that you need to do so. So it seems like in this case, Cotter, he knew that was coming down the pipeline, and at least he, according to the complaint here, he told Subway that, hey man, I'm gonna terminate my lease because I'm gonna terminate my franchise agreement because my lease is expiring, and essentially he couldn't renegotiate a new lease. So again, you got to mind the lease. The owner of the building may be separate from the franchisee or the franchisor, in this case, Subway. So you may have three parties in this case: Subway, which is the franchisor, the franchisee, which is in this case Cotter. Then you may have a third party who actually owns the building that you have to renegotiate the lease. So now Cotter is at least purporting the Subway that like, hey man, this guy, inflation is killing him. He essentially wants to charge more money. I can't do that. I'm operating on razor thin margin. So can I just close this store? And Subway like, all right, cool. You can do it, whatever. And it seems like at least what Subway is trying to say that his plan all along was not, he was trying to close the store because the lease was maybe getting too expensive. He had this backdoor deal with his buddies to say, hey, look at this, the plan. We're going to close this store. We're going to open up a store called Sub. That way, I already got, look, trust me on this one, guys. I got all the menus we're going to still use, the color scheme, all that. We still got the ovens from Subway. We got their proprietary and confidential systems and processes that we can operate to kind of run a business. We don't got to pay a third-party company for that. And one other thing, I don't got to pay this franchise fee that, again, I'm not sure what the franchise fee is, but I would imagine that the franchise fee is typically they're a percentage of the revenue that you're getting in. So say in this case, if this restaurant was making $500,000 and they had to pay 10% to Subway, the franchisor, that's $50,000. So he essentially is saying, hey man, everybody still thinks it's Subway. They're gonna come in, they're gonna see all this stuff. So they're gonna think this Subway, but now I don't gotta pay the Subway. We don't have to pay the Subway franchise fee because we're not a franchise of Subway. We're doing this on our own. So that's pretty much what Subway is saying, what really was going on. And they're calling them out on it. So I mean, that's interesting. That is interesting stuff. So let's get back to it. So I think we just read 30 here. Let's go to 31. Cotter was contractually required under his franchise agreement with Dow upon closure of the restaurant to de-identify. They talked about that earlier. The premises and change his appearance. It seems like this contractual requirement include removing all the trademarks, signs, colors, structures, trade dress, menus, food, point of sale system software developed by Subway, printing. I mean, all the IP. Seems like Cotter failed to de-identify the premises. Again, I still think that Subway, it was a big minutes. I think they got to shore up their, I guess their de-identify process, because let 5 months go by before you pick up on that. I think it's a flaw in the system. Upon information of belief, Cotter instead worked with the defendants to transfer the premises and all of its contents, including the equipment and IP, to operate a Subway restaurant to defendants sometime. So essentially, what Subway is saying is, hey, man, Cotter, he just essentially gave it to the defendants, and he probably involved in some way, more of a silent partner, or maybe just getting a kickback. That's pretty much what Subway is alleging here. Subway became aware in May of 2024. I talked about that. They were operating what's the name of the sub? So let's get down to see if they're talking about. Okay, let's Exhibit A is so they talked about they sent a cease and desist letter to defendants in May of 2024. Let's look at the cease and desist letter, because this may be interesting. Can I pull this up? We're gonna quickly go through that. We're gonna quickly go through the cease and desist letter. And this seems like this is a Connecticut law firm, Wiggin and Dana. So this Mr. Sider, dear Mr. Sider, this is the cease and desist of unauthorized use of Subway IP. I went to his email, as you see here. I actually gotta write a Subway. Write a cease and desist letter. So I'm not looking forward to it, but it is what it is. So the firm Dow, which is the franchisor of the Subway system in the U.S. and Subway IP, the owner of the IP related to the operation of Subway, including all trademarks, trade dress, so forth and so on, is a franchise, and it has over 18,000 locations in the U.S. It seems like they picked up 2,000 locations since March 2024. A Subway restaurant was operated pursuant to a franchise agreement between Dow and Cotter on P Street until November 30th, 2023, at which time the Subway restaurant closed. Dow has become aware that Subway has become aware that a sandwich business located on the premises, now operating under the name Sub, has been informed that you guys, 706 Piece LLC, is operating a Sub restaurant. Upon inspection, it is clear that the interior of the Sub restaurant is virtually indistinguishable from that of Subway, including all this decor, trade dress, Subway marks, so forth and so on. The sub restaurant is not authorized to use any of SIP's IP, including without limitation its trademarks, trade dress, all that stuff, and confidential information. The sub restaurant in your improper and unauthorized use of SIP's IP constitutes an infringement of the intellectual property. Moreover, the sub restaurant in your unauthorized use of Subway marks, trade dress, all the IP and goodwill associated with the Subway brand interferes with Dow's relationship with his franchisee. So it seems like the other franchisees, y'all messing up our money pretty much. These brazen acts of trademark and IP infringement, unfair competition, and unfair trade dress practices subjects the owner of the sub restaurant, including but not limited to 706 Peace LLC, essentially trademark infringement, so forth and so on. Dow and SIP cannot permit the unlicensed and unlawful use of SIP's valuable IP and its goodwill or interference with Dow's franchisee relationships and must take all necessary steps. Again, that's the whole part of owning trademark. You have to defend the trademarks if you get wind that they're being infringed on. So they're saying this is the demand. They demand them, 706 Peace LLC, to permanently and immediately cease all use of the SIP's IP. And this is some of the stuff that they're saying that y'all need to essentially remove. So what y'all think? That's pretty much the brass tacks of it all. John Doragazi, it seems like the attorney who wrote it all. So, I mean, again, that's essentially that's the cease and desist letter. So let's get back to it here. Hold on, did I just pull up? Come on, man. I didn't try to pull up that. Pull back up the complaint here. So this is the complaint. That's if you go to 38, that Exhibit A was the copy of the cease and desist letter that we just read. Seems like 39 defendant failed to respond to the May 24th cease and desist letter. On June 3rd, Subway again inspected the premises, and the restaurant continues to operate at that location, retains all the features that would cause it to be confused with the Subway restaurant and approved food product. The following pictures demonstrate it. Okay, so this is the good stuff, y'all. These are the pictures. Oh, man. They didn't even got the lady in the shot. So, looking at the pictures, do you guys think that this still Subway? Like I said, you still got the vegetables, the condiments, dressings. Those are still laid out. It seems like in a way that you will see at a Subway restaurant. You still got the cookies next to it. I like that macadamia and raspberry. Them joints used to slap. Look at the menu. The menu still looks the same. Chips still lined up the same way. They still got the cheeses and some other condiments looking the same. Oh, man, they still got the Subway oven. This is what I'm saying. You guys got to be smarter than this. Look at, they got the Subway series. So they're essentially still using all the menu, all the ovens, the trademarks, the drink fountain. Come on, man. You can't do this. The tables you look at. This looks like a Subway restaurant to me. What about y'all? Mind you, what we're looking at now is supposed to be a sub restaurant that's not affiliated with Subway. Let me know in the chat if you guys think that this looks like a Subway restaurant. Got the order. You see the tape job, though. You see they tried to get cute. You see they tried to tape up the Subway restaurant here. Or the Subway sign to the left here that you see. They still got the bread. Defendants are not authorized franchisees or otherwise related to plaintiffs in any matter whatsoever and are not now and have never been authorized to use the Subway marks or systems. Defendants' use of the Subway marks and systems enables defendants to trade upon and utilize the goodwill established by plaintiffs and Subway franchisees. So again, the whole point of trademark is so that somebody pulling up to the restaurant, again, this help the consumers identify the source of the goods and services. So if you're pulling up to get a Subway sandwich and you walk into this thing and it's like, man, okay, this looks like a Subway restaurant. Okay, the food looks like it's similar to a Subway restaurant, but it's not Subway. That's the whole point of trademark law, really to protect the consumers, to help them identify the source of the goods and services. And it seems like in this case, Subway is saying that this is confusing our customers, and they're essentially trying to trade off our name. So that's essentially what is going on here in paragraph 42. Let's go into paragraph 43. Defendant's use of plaintiff's marks, trade dress, and all the other IP has and will cause consumers to mistakenly assume that there's some association, approval, sponsorship, affiliation, so forth and so on with Subway. I would probably tend to agree with it based on what we just looked at. For example, defendants attempt to alter the menu board by covering the word Subway in the Subway series. You see that's what this was right here. See the menu board, they try to cover up, seem like some duct tape here. The Subway sign. Look like they even got a crossword puzzle here. But that's what they're saying in 43. They try to cover up the Subway, covering the Subway and the Subway series logo with a sticker saying new demonstrates their intent to trade on plaintiff's goodwill. Any person entering to the sub restaurant will see this logo from a distance, and the sandwich is listed on a menu board and think essentially that is dealing with a Subway. Defendants the cease and desist letter sent on May 24th to defendants notified them of their unauthorized use of the plaintiff's IP before filing of this action. Again, the judge gonna want to see that you at least attempted. Sometimes people send 2 or 3 cease and desist letters. Seems like Subway after the first one said, "Okay, we're gonna slap y'all with that lawsuit." Defendants are therefore fully aware of the IP rights of Subway and have acted and continue in a reckless disregard. So we got the trademark infringement. Defendants without plaintiff's consent have used and are using the interstate commerce a mark or name Subway and various other marks associated with it, including a number of registered sandwich names. That's essentially associated with trademark and associated with Subway and protected by Subway in violation of the trademark law, USC 1114, which is essentially the Lanham Act. Upon information of belief, the adoption and the use by defendants of various Subway marks and IP in connection with their commercial activity was in bad faith. And anytime you see that willful disregard, they're going to ask for treble damages, which is 3 times the damages. Willful disregard of plaintiff's rights with intent to trade on and appropriate the reputation and goodwill which plaintiffs have built up. I would probably agree with them. So without an injunction, an injunction is they want the courts to say, hey, y'all got to stop using the protected, the IP that's owned by Subway. That's essentially what an injunction is. So defendants they're ordering the court to issue an injunction so that the defendants, Cotter and the guys, can cease use or display of essentially all the IP. So that's the same thing. It was another one more. I'm not going to go on a false designation. It was another one that talked about the trade secrets, which you typically don't see. And trade secrets is typically left to the state, even though it's a Uniform Trade Secrets Act. Those normally are kind of left to the state. Let me see if I can kind of find it here. So, okay, you see here, violation of North Carolina's Trade Secrets Protection Act. So again, those are normally left to the state. Let's go start with 86, the system for operating the Subway. So this is the system for operating the Subway, including the methods of operation, food preparation, service, trade dress, recipes. It's confidential. It's not shared with the public. So again, let me go back a little bit. The trade secrets is information, confidential information that gives you an economic advantage over the market. Just think of Coca-Cola. It's a trade secret, a formula for Coca-Cola, and that gives them an economic advantage over the market, being able to sell a ton of Coca-Colas. People love Coca-Cola, and that's because of the ingredients, the process of which it is made. All that is not known, and as long as Coca-Cola can keep that confidential, keep that protected, then the trade secret will last forever, as well as the trademarks. Trademarks and trade secrets last forever. We know copyrights last the life of the author plus 70 years. We know that patents last 20 years, at least a utility patent does. Design patent lasts 15 years. But trade secrets and trademarks last forever. In the case of trade secrets, as long as you keep it secret. To the extent that the secret is out the bag, the cat is out the bag, then it's no longer a trade secret and people can use it. As long as they don't get that trade secret by improper means. Misappropriation is what we call it. So, again, I think that's important information to note, which that's essentially what Subway is saying here. They're getting this. They have the confidential information, but essentially they got it through improper means. 87, upon information of belief, defendants have obtained essentially the confidential trade secret information from Mr. Cotter or others of how to operate a sandwich restaurant in the same manner, using the same method. So again, improper means, defendants were not authorized to have access to such information, and indeed knew or should have known that it was confidential, and they are not allowed to use it. They're just giving you the statute North Carolina that protects that. They're even saying violation of Copyright Act. So we're not going to go over that. But again, I kind of. So what do you guys think about this, man? There's some serious stuff. There's some serious stuff. So wait, I'm not sure what's going on in North Carolina, but it seems like these restaurants are going rogue in North Carolina. Former authorized franchisee seems like he gave. Just think about that. Your buddy, like, hey man, this is our plan. Y'all gonna operate this restaurant. Look at, I know y'all don't get no knowledge of how to operate a restaurant or a sandwich shop, but I got the secret sauce. I'm gonna step out. Y'all just probably gonna give me a couple dollars. We don't have to pay Subway the franchise fee, and we are gonna make money. And they probably like, okay, bet, let's do it. And here we are. You're not going to get away with this stuff, people. Especially with a company like Subway, these more famous companies, the Chanels, the Nikes, the Adidas, they're going to catch you. And when they catch you, they're going to hit you with a lawsuit. And at the very least, they're going to get you the court is going to issue them an injunction for you to stop your cease all operations. But in the best case scenario, you're going to get hit with money damages, with treble damages, and that's going to set you even further back. So again, it's not worth it. Hopefully you guys got something out of this today. I thought this was a good one because they had that franchisee or essentially that franchisor franchisee dynamic, which we hadn't talked about or hadn't came up so far during these lives where we talk about the IP lawsuits. And again, this was an interesting one because they're talking about everything of all the intellectual property, short of patents, copyrights, trademarks, trade secrets, the defendants and friends, all of those, which again, kind of we talked about, and it looked like Subway got a good claim here. So I'll try to keep up with this, kind of bring you guys what end up being a final straw. I know it's going to be some type of settlement. These cases rarely go to trial where, the judge or the jury is going to rule on this. These typically are going to get settled, which involves the defendants having to stop operations. I guess they made their money in the interim. So they had 6 months, 7 months, maybe up to a year of, being able to make a couple dollars illegally. But again, you'll just be better off spending that year doing something productive, trying to build your own company, protecting your own IP, and kind of establishing your own brand. That's at least my take on it as an IP attorney. But I guess what do I know? So again, until next time, until next Sunday, hopefully you guys got something out of that. Remember, protect that IP. Trademarks, copyrights, patents, trade secrets. This stuff is extremely valuable. And I want all you guys to create, invent, brand, protect the IP, and come back and let me know, hey man, you kind of jump started my entrepreneur endeavor to go into business and protect my IP. So that's all I have for you guys. I'll see you guys next time. Peace.